There's a knock at your door. You look through the peephole, men in vests, badges. One of them holds up a piece of paper and says 4 words. "We have a warrant." Your heart stops. You think it's over. You think you have to open that door. But in the next 30 seconds, one decision will either protect every constitutional right you have or hand them away completely. And the terrifying part? Most people give those rights away without knowing they ever had them. Every single day across America, people open their doors to ICE agents holding a document they've never learned to read. They don't know that 2 completely different documents both carry the word warrant. They don't know that one of them does not give agents the legal authority to enter your home. And they don't know that the moment you open that door, you may have just consented to something a judge never authorized. I've analyzed the federal case law, the Immigration and Nationality Act, and the actual government forms ICE uses in the field. And what I found is a distinction so critical, so legally decisive, that knowing it could be the difference between staying in your home and being detained on the spot. This is educational content only. For guidance specific to your situation, consult a licensed immigration attorney in your jurisdiction. Today, I'm going to walk you through 4 exact things you must check the moment ICE says they have a warrant. Miss any one of them, and you may give up rights the Constitution guarantees you. Understand all 4, and you will know exactly what you're looking at, exactly what it authorizes, and exactly what to say. Let's start with the most important legal concept most people have never heard of. Mistake 1. Not knowing the difference between an administrative warrant and a judicial warrant. The mistake, the knock comes. The agents hold up a document with official lettering, government seals, the word warrant printed clearly across the top. You think a warrant is a warrant? You open the door. But here's what almost no one outside a law school classroom knows. There are 2 completely different documents that use the word warrant in immigration enforcement, and they carry radically different legal authority. The scenario. ICE agents arrive at your home. One of them holds a document called a Form I-200. Warrant for arrest of alien. Those are the exact words printed on the top. It looks official. It has a seal. It has a signature. You open the door. That document was not signed by a judge. It was signed by an ICE officer. And that single fact changes everything. Why people don't know this? Nobody teaches this distinction. The word warrant carries the same psychological weight, whether a federal judge signed it or an agency officer signed it. Officers are not required to explain the difference. They present the document. Most people comply because they believe they have no choice. The legal reality. Under the 4th Amendment, which protects every person physically present in the United States, citizen or not, the government cannot enter your home without either your consent or a warrant issued by a judicial officer. The Supreme Court in Payton v. New York, 1980, established that the home is the most protected space under the 4th Amendment, and that entry requires a warrant from a neutral magistrate. An ICE administrative warrant is not issued by a neutral magistrate. It is an internal agency document issued under the authority of the Immigration and Nationality Act. As the Federal Law Enforcement Training Center's own legal instructors have publicly stated, an ICE administrative removal warrant gives an officer roughly the same authority as a criminal officer who has probable cause but no judicial warrant, meaning they can arrest in public spaces but cannot force entry into your home. The evidence problem. If you open the door voluntarily, courts will interpret that as consent. It doesn't matter that you didn't understand the difference between the 2 documents. It doesn't matter that you felt you had no choice. Once you open that door, the encounter is treated as voluntary in the eyes of the law. The correct move. Here is check number 1. Do not open the door. Speak through it. Ask them to hold the document up to a window or slip it under the door. Then look for one thing, the issuing authority at the top of the page. A judicial warrant will say United States District Court, or name a specific federal court at the top. It will be signed by a federal judge or magistrate judge. An administrative warrant will show the seal of the Department of Homeland Security. It will be titled Warrant for Arrest of Alien, Form I-200, or Warrant of Removal/Deportation, Form 205. It will be signed by an immigration officer, not a judge. If it says Department of Homeland Security at the top, and there is no federal court named, you are looking at an administrative warrant. You are not required to open your door. Say this calmly and clearly through the closed door. I am not going to open my door. I do not consent to entry. Bottom line, the word warrant alone means nothing. Who signed it is everything. A document signed by a DHS officer is not the same as a document signed by a federal judge, and only the judge-signed document has traditionally authorized forced entry into your home. Mistake 2. Not checking whether the warrant names you and your address. The mistake. You've looked at the document. It is a judicial warrant. You feel the legal weight of it and you open the door. But there is a second check that most people never make. A warrant that is real, valid, and judge-signed can still not authorize entry into your home if it doesn't specifically name you and specifically identify your address. The scenario. Agents present a valid judicial warrant. It's signed by a federal magistrate judge. You open the door, you comply. Agents search the residence, but the warrant names someone who used to live at your address 2 years ago. Or it names a person who lives at a different unit in your building. The document was legally issued, but it was never legally authorized for your home, for your family. Why people don't check this? When law enforcement presents any official document under pressure, most people don't read it carefully. The psychological authority of the badge and the uniform creates urgency that overrides careful reading. Agents are trained to project confidence and momentum. Most people open the door before they've read a single line. The legal reality. The Fourth Amendment's warrant requirement has always demanded particularity. The warrant must describe with specificity the place to be searched and the person to be seized. This is not a technicality. It is a core protection that goes back to the founding of the country. The framers wrote the Fourth Amendment specifically because of general warrants issued by the British Crown that authorized searches of any home without naming a specific person or place. A warrant that does not name you or does not identify your specific address does not give agents authority to enter your specific home. This principle is long established in federal courts, the evidence problem. If you open the door to a warrant that doesn't name you, and agents find something during their search, your attorney will have grounds to challenge the entire search. But only if the record shows you did not consent. If you open the door voluntarily, the consent argument complicates everything. The correct move. This is check number 2. Before you open the door or consent to anything, read these 3 things on the warrant. The name of the person it authorizes action against, the address it specifically identifies, and the date any warrants can expire or be executed outside a valid time frame. If the name on the warrant is not yours or the address does not match your unit or residence precisely, say this through the closed door. The name on that warrant does not match mine. I do not consent to entry. If agents tell you the person named on the warrant is believed to be inside, you are still not required to open the door. The legal burden is on them to establish that. Your obligation is not to make their job easier. Bottom line, a valid judicial warrant that names someone else or a different address does not authorize entry into your home. Particularity is a constitutional requirement, not a formality. Check the name, check the address. Mistake 3. Answering questions about immigration status. The mistake. You've checked the warrant, you're standing in the hallway or at the threshold. An agent looks at you and asks, "Are you a citizen?" Or, "Where were you born?" Or, "Do you have documents?" Most people answer, they think cooperating will help them. They think silence will make them look guilty. They answer and in 30 seconds provide the exact information that becomes the basis for detention. The scenario. An agent has just confirmed the warrant doesn't fully apply to your situation, but he's still standing there. He looks at you and says, "Can I just ask, where are you from originally?" You say the name of your country, he follows up. "And what's your current immigration status?" You explain. In 2 sentences, you have told an immigration enforcement officer the answer to the only question that matters for their purpose. Why people answer. The question sounds casual. It sounds like basic conversation. Agents are trained to ask questions in a tone that suggests they already know the answer and are just confirming. Most people don't realize that a casual question asked by a federal officer in an enforcement context is evidence gathering, not small talk. The legal reality. The Fifth Amendment of the United States Constitution protects every person physically present in the country from compelled self-incrimination. The Supreme Court in Matthews v. Diaz, 1976, confirmed that the Fifth and 14th Amendments protect every one of these persons, referring explicitly to the millions of non-citizens within U.S. jurisdiction, from deprivation of liberty without due process. In Plyler v. Doe, 1982, the Supreme Court reaffirmed that even undocumented individuals are persons entitled to constitutional protections, including due process under the Fifth Amendment. You are not required to answer questions about your birthplace, your nationality, or your immigration status. Any answer you give can be used in removal proceedings against you. There is one important caveat. You cannot lie to a federal officer. Making false statements to a federal agent is a separate criminal offense under 18 U.S. Code Section 1001. The protection is the right to stay silent, not the right to provide false information, the evidence problem. Unlike a traffic stop where body cam footage might be reviewed months later in a local courtroom, statements made during an ICE encounter can be introduced directly into civil immigration proceedings. There is no Miranda warning requirement in a civil immigration context. ICE officers are not required to inform you of your right to remain silent before asking questions. If you answer, those answers are admissible. If you stay silent and invoke that right explicitly, you've protected yourself. The correct move. This is check number 3. The moment any question goes beyond identity confirmation to immigration status, to national origin or where you were born, say this clearly. I am exercising my Fifth Amendment right to remain silent. I will not be answering questions without an attorney present. If they keep asking, repeat it. Do not explain. Do not elaborate. Do not try to help the situation by offering context. Just invoke. Also critical, do not sign anything. ICE agents sometimes present documents in the field and ask for a signature. One of the most common is a voluntary departure order. Signing it can mean waiving your right to appear before an immigration judge. Say clearly, I will not sign any documents without speaking to an attorney first. Bottom line, your right to remain silent applies to immigration encounters. You do not have to answer questions about your birthplace, nationality, or status. Invoke it explicitly. Say the words. Do not sign anything. Mistake 4, not knowing you can demand to call an attorney before complying further. The mistake. At some point in the encounter, agents say they are detaining you. You don't know what to do. You feel the situation closing in. You comply with everything because you believe that once detention is announced, you have no remaining rights. But you have a right that many people in this exact moment don't know they have. The scenario. Agents announce they are taking you into custody. You're in the doorway or outside your home or in your car. You don't resist because resisting would be dangerous and could result in criminal charges. But in the chaos, you say things. You answer questions in the back of a vehicle. You don't ask for an attorney. You are placed in a detention facility. Weeks later, statements you made in those first 30 minutes appear in your immigration proceedings. Why people don't ask for an attorney. Most people believe an attorney is something you get after you've been processed and formally charged. They don't know that the right to seek legal counsel begins the moment you ask for it, and that asserting it can pause questioning immediately. The legal reality. While non-citizens in civil immigration proceedings do not have a Sixth Amendment right to a government-appointed attorney, unlike in criminal court, they do have the right to be represented by an attorney of their choosing at their own expense, and they have the right to request one before answering questions. The moment you say, I want to speak to an attorney before answering any questions, agents are on notice that you have invoked that right. Any statements taken after that invocation without access to counsel face serious scrutiny in proceedings. Additionally, under Zadvidas v. Davis, 2001, the Supreme Court confirmed that the Due Process Clause applies to all persons within the United States, including those facing civil removal, which means procedural protections, including access to counsel, are constitutionally grounded. You also have the right to make a phone call to notify a family member or attorney that you are being detained. If you have an attorney's number memorized or written in your wallet, say, I am requesting the opportunity to call my attorney. The evidence problem. Everything you say from the moment of detention forward can be used. There is no cooling off period. There is no moment at which the record is wiped and the formal proceedings begin. The encounter from the first question to the last signature is a legal proceeding. Treat it that way. The correct move. This is check number 4. If you are being detained, say this immediately and clearly. I am invoking my right to remain silent, and I am requesting an attorney. I will not answer any questions or sign any documents until I speak to an attorney. Then stop talking. If they continue asking questions anyway, do not answer. Keep repeating those 2 sentences if necessary. Remaining consistent from the first moment of detention is the strongest position you can be in when proceedings begin. Bottom line, detention is not the end of your rights. It is the moment you must activate them most clearly. Ask for an attorney. Stop answering questions. Do not sign anything. Here's the truth about what happens at that front door. The moment an ICE agent says, "We have a warrant," the legal encounter has already begun. Every second from that point forward is evidence. What you say, what you open, what you sign, what you consent to. All of it goes into the record. The law does not protect people who panic. It protects people who know their rights and assert them calmly. Let me give you the 4 checks one more time. Write these down. Put this information somewhere you can find it quickly. Check 1. Who signed the warrant? Department of Homeland Security seal means administrative warrant. No judge signed it, no obligation to open your door. A federal court heading with a judge's signature means judicial warrant. Different rules apply. Check 2. Does the warrant name you specifically and does it identify your exact address? If it doesn't match, it is not authorized for your home. Check 3. Do not answer questions about your birthplace, nationality, or immigration status. Invoke your 5th Amendment right to remain silent. Say those words out loud. Do not sign anything without an attorney. Check 4. If you are detained, immediately request an attorney and state you are invoking your right to remain silent. Repeat it as many times as necessary. Do not answer further questions. 4 checks. That's what stands between a knock at the door and the loss of every protection the Constitution gives you. Program a free immigration legal hotline into your phone before you ever need it. The ACLU, the National Immigration Law Center, and local legal aid organizations offer emergency guidance. Have a plan before this happens, because when it does happen, your heart will be racing, and you will not have time to think. This is educational content only. It is not legal advice. If you or someone you know is facing an immigration enforcement situation, contact a qualified immigration attorney immediately. If this helped you understand your rights, share it. Not for the views, because someone you know may be standing at that door and they deserve to know what you now know. The Constitution does not protect people who don't know it applies to them. Now you know.